The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome, counsel. We look forward to your arguments this afternoon. I'll ask Mr. Doug Shima to please call the 1:30 docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Tuesday, May 25th, 2021 consists of two cases. The first case on the docket is appeal number 121459, State of Kansas versus Kora, Lyles, Shawnee County. The second case immediately following will be appeal number 116541 in the matter of Scott M. McFall, original action and attorney discipline. Your Honor, the appellant in State v. Lyles 121459 has reserved 2 minutes rebuttal. We are ready to proceed on the first case.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Merrill Carver-Allman, Capital Appellate Defender, on behalf of Ms. Lyles, present and ready for argument.
May it please the court, the state appears by Deputy Solicitor General Chris Elsleger, ready for argument.
Thank you, counsel. Ms. Carver-Allman, you may begin your argument.
Thank you, Chief Justice. May it please the court, this case is about violations of the presumption of innocence. Fueled by methamphetamine and other drugs, Ms. Lyles' boyfriend, ex-husband, and 3 acquaintances tortured and killed 3 other people while they were all visiting Ms. Lyles' house on March 11th in 2017. Ms. Lyles was allowed to leave before the murders took place, but she was charged along with 4 other co-defendants, and she was ultimately convicted of 3 counts of felony murder, among several lesser charges as well. And the big picture question for the jury to decide here was whether Ms. Lyles was a bystander or whether she was a perpetrator. And I acknowledge today that there is conflicting evidence on that. But the problem here is that the jury was not allowed to weigh that evidence fairly because of prosecutorial error and instructional error that compounded together to weaken the presumption of innocence. So my plan today is to go through those trial errors, take the prejudice of those errors cumulatively, and then hopefully have some time to talk about the sentencing issue at the end as well. So starting straight in on this prosecutorial error, what we're arguing happened here was that the prosecutor made a misstatement of law when he argued that the accomplice witness instruction, the instruction that tells juries that they should consider the testimony of accomplice witnesses with caution, when the prosecutor argued that that applied to Ms. Lyles, that was a misstatement of law. And the Court of Appeals talks about the bounds of what you can instruct on when you're talking about the defendant's credibility in this land case that we've cited in our briefs. And there they say, you can say she's an interested party. You can maybe say she has reason for bias, but you can't single her out as not to be believed. And those limitations are all based in the 6th Amendment. This case is in a different procedural posture than land because land was an instructional issue and we're arguing this here as prosecutorial error. But in land, that was clear error. There wasn't even an objection and the court found that it was so bad that they reversed the conviction. And here, the state cites cases that hold that a prosecutor can talk about motive and bias, and that's all true. But the prosecutor crossed the line when he gave that argument the sort of imprimatur of a jury instruction, of the court is instructing you to do this, not just me pointing out the flaws and weaknesses in the other side's case. But then moving on to the instructional error.
Let me back you up, counsel, sure. Because before we move on, I'm having trouble applying the land case to this case because in land, all of the defendants were tried together. The only defendant to testify was land, and then the court gave that accomplice testimony instruction, which really does single out land because that was the only defendant that testified. And here, when you look at what the prosecutor said, I would say in context, he talks about the accomplice instruction, but then explains why that testimony, they get a benefit, so there's an interest there. And then he just comes in and says that also applies to Lyles because she has a bias in her testimony, and then goes on to explain why she would have an interest in distracting the jury. And I think that part's, I'm having trouble understanding why the prosecution can't articulate reasons why the defendant's testimony is inconsistent and therefore not reliable.
Well, and our argument, Justice Lyles, is that the prosecutor can do that. It's the saying that the court is instructing you to do that too. That's really the problem here. And I understand that it's, you know, I think it's like the instruction is cited in one paragraph, and then he says it applies to Lyles in the next paragraph. But I would argue that that is actually slightly different issue at hand. But in McBride, it was that same kind of, couple sentences of disconnect. And this court found that that was reversible too there. And that was the case where the prosecutor commented that the witness was entitled to the same presumption as the defendant. So, similar issue, not exactly the same issue, of course. But that's our argument on that issue, at least.
Counsel, the argument is, I think after he references the instruction, it's the word "that" applies here too. Isn't the prosecutor just referring to the rationale encompassed within that instruction, that somebody who has perhaps a benefit from their testimony, you might want to consider with caution? And then that applies to Lyles and then he explains the rationale for that. And so I guess the word "that" is used, and I'm not sure how we can tell from the record if that's a reference to the instruction or the rationale within it.
Yeah, and it's you do have to get into some sort of grammar deconstructing of the sentences, but I think it's at least very likely that it referred to the instruction. There are two possible interpretations there. It's not super clear, and that in itself is problematic.
The potential for confusion alone.
Exactly.
Okay.
But is that confusion clarified or kind of mitigated at least by what the prosecutor says from that point on, which is she has a bias to mislead you, a reason, and spends quite a bit of time talking about why there is that bias and why that might cause them to want to really examine her testimony as it sits with the other testimony.
I would argue that almost makes it worse because, again, it's the tying it to the instruction that's problematic here. And then the rest of the jury instructions didn't fix that at all. And that's also problematic because, of course, the instruction was given that the defendant is entitled to the presumption of innocence. But if we're also considering her as an accomplice, then, those instructions are confusing. And that's without even getting into the next issue about the witnesses who testified in exchange for benefits instruction. And if there are more questions about the prosecutorial error, I'd love to take them. But otherwise, I think I will move on to the instructions. And first point on the instructions is, I think the state is largely misconstruing our argument. The final instruction that was requested here did not say informants, it said witnesses. So to the extent that the state is arguing that Mr. Folsom and Mr. Mays weren't informants because they weren't acting as state agents, that's really a red herring there. We're talking about witnesses. Also, moving on to the legal appropriateness, the question is, and I think we lay this out in our brief about as well as I can, does this fairly and accurately state the law? And in Allison, this court said it does. And I think I might have been a little overstrong in my brief in discussing Dean, because I don't think that the court needs to overrule Dean to side with us today. In Dean, as I was looking at it last night, that was not a requested instruction in Dean. So there's a little bit of overlap between the legal appropriateness and the prejudice part of it. But it's a different case here where the defendant is requesting a legally appropriate instruction, I believe, rather than asking a district court judge to pull one out of the air that, while it may be correct law, district court judges don't have to necessarily instruct on every single element of the correct law in the whole universe. But where you have a party actually requesting the instruction, that seems distinguishable from what this court held in B. And looking at those errors cumulatively, again, the only question was who was culpable for what here. And we have two connected errors. We have Mays and Folsom's testimony, which first of all was not entirely consistent. They had strong motivation to deny their involvement. Folsom, even in his testimony, did say that he had asked the other men to stop once the killing started, and Mays' testimony doesn't reflect that. So it looks like Folsom is deflecting a little bit there. There's also a time period where Folsom was gone and Mays was there. And during that time period, it's a little hard to tell because, you know, people's recollections are discombobulated. But Mays said that Miss Lyles said they all have to die. And that's a pretty damning statement as far as intent goes and whether she was leading the show here. And Folsom didn't corroborate that at all. So for that, in addition to the confusion in jury instructions, we are asking this court to reverse Miss Lyles' convictions and send her case back for a new trial. But I see I have 3 minutes left, so I have to get to this sentencing issue because I think it's a really interesting sentencing issue. The first thing that the state is arguing is that we haven't preserved this issue. How? We haven't preserved this issue somehow. And of course, we are arguing that there was an objection. Even if there wasn't an objection, she has a fundamental right to due process, and that right is violated when the state breaches a sentencing agreement. There is also, to the extent that that is discretionary review rather than mandatory review, there is also, I believe, a strong interest for this court, in the Sherman case, which is cited in other places in this brief. This court talks about its duty to oversee and ensure the integrity of the criminal justice system. And that's another reason, even if you don't think there's an objection, which again, we do, that's another reason that I think the court should really reach this issue. The second argument the state makes is that there was a lack of agreement about the terms, but the prosecutor himself says she, Miss Lyles, indicated a willingness to cooperate in the prosecution of the remaining individuals, which would have been Mr. Flowers and Mr. Lowry, obviously in exchange for some consideration, some mitigation on her sentencing here today. And that's in volume 20, page 10 through 13 in a larger chunk of text. So the state sets out what the terms of the agreement are. To the extent that cooperation is ambiguous, first of all, ambiguity goes to the state. They control this process. They are the drafter in contract terms here. So it's if it's ambiguous, tie goes to Miss Lyles. Also, there is established case law in Dixon particularly that the state can't bargain for even a particular version of testimony. All they can say is truthful. But if the state gets to say, you can testify truthfully, but then we'll decide if it was truthful or not at the end, we're going to be the sole arbiter of that. That is a hole you can drive a truck through on this issue. And it allows the defendant to be taken advantage of, which is what we're arguing happened to Ms. Lyles here. I still don't know what she was supposed to say. If she had gotten up, obviously the testimony she gave wasn't good enough for the state. They didn't think that that was truthful. If she had gotten up though and testified to something differently, I cannot imagine a world where the prosecutor or the defense attorney in Mr. Lowry's case wouldn't have gotten up with her trial testimony in hand and said, okay, but what about this thing you said here? What about this thing you said here? Were you lying then? Are you lying now? And just impeached her to pieces. So I don't know how the state's strategy here even makes sense. It's very difficult to see why they would want her to testify in a way that enhanced her culpability when they're trying to prove her co-defendant's guilt. None of this makes sense to me, except as a way for the state to have their cake and eat it too. And if that's what happened here, which we believe it is, that is an error that needs to go back for correction for a new sentencing hearing in front of a new judge, where the state is ordered to meet the promises it made under the sentencing agreement. If there are any other questions, I'd be happy to take them. But otherwise, I think I got through everything I wanted to.
It seems to me on this last sentencing issue that you're basically saying you've got a handshake, and the state in this handshake, which we don't have any evidence on because nobody did anything to articulate what this agreement really is about, that somehow the state lost the ability to evaluate on a good faith basis whether there was compliance with this handshake. And this is not a plea bargain. This is after that, after conviction, she doesn't have a Fifth Amendment right. All the law you cite is about plea bargain. I'm having trouble figuring out the framework to analyze this on. We don't have a record. We don't have any case law. And the rest we have is just this vague notion that they had a handshake. That we might give you some consideration if you testify for this guy. That's what we've got. How do we enforce that? How do you find a violation of it?
Well, as I said, Justice Lyles, I think there was a record. I think the state said what the terms were. I also want to check, and maybe I can answer on rebuttal, because I think Dixon, actually, I think there was an element of sentencing in Dixon, but I want to check and make sure on that before I say that for certain. She doesn't have a Fifth Amendment right to be certain, but she's still, anytime someone testifies against a co-defendant, they're putting themselves at risk, especially someone that's going to prison for a long time. So, to the extent that that you're arguing, and I'm not sure that you are, but that she didn't give up anything here, I would disagree with that and say that she most certainly did. She gave up some degree of safety in prison for the rest of her life to testify on behalf of the state. So I think that maybe answers your question.
Well, the problem is that this was said during sentencing. The defense lawyer sort of shrugs his shoulders and says they didn't do what I thought they were going to do. And then we move on with sentencing. And I would think that what we would need to do would have been to stop and make a record if really an agreement was breached, so that, appellate counsel like yourself would be able to have something to argue from other than some just vagaries, especially something that's important.
And I certainly do. I mean, it would be better if there was a written agreement here. There are lots of things that could make this better. The question is, after what happened, do we have enough record to go on? And my argument is that we do.
Any other questions?
Thank you.
Thank you, counsel. Mr. Elschlager?
Thank you. May it please the court, Chris Elschlager for the state. Addressing the prosecutorial error claim, essentially what the prosecutor did here was tell the jury that it makes sense to view the defendant's testimony with caution. And if that is not within the wide latitude allowed in closing arguments, then we're not talking about a very wide latitude at all. I mean, I think it's perfectly within the bounds of counsel's argument to say, this person may have a bias and you should view her testimony with caution. Just like the other people who potentially have biases, you should view their testimony with caution. With respect to the instructional claim, I mean, they asked for an informant testimony or an informant instruction. And the trial judge said, well, there's been no informants testify. And even the defense counsel acknowledged that. No one that testified met the definition of an informant, which is someone who acts as an agent for the state while collecting the information. They were accomplices, and they were getting or hoping to get a benefit for their testimony, but the accomplice instruction was given, and that told the jury to view their testimony with caution, because as the prosecutor said earlier, they could potentially have a bias. There is no requirement for an informant instruction, and it would have been factually inappropriate.
Counsel,
yeah.
What is our legal standard when we review a denial of a requested instruction? Do we evaluate the propriety of the requested instruction that was not given, or the propriety of the instruction that it was ultimately given by the court?
Well, I think when instruction is requested and not given, there's the four parts test. I'm thumbing through my brief here to look for it, but basically you look to see if it is legally appropriate. Well, first you look for preservation. Okay, it was requested. And
I
then
guess my question is it the requested instruction or the one that was given?
Well, I think that the issue they're raising is that the requested instruction wasn't given. That's the alleged error. I do think, though, that the instruction that was given, if the appropriate instruction, if they're alleging one instruction should have been given, but a different instruction was given, well, then I think it does weigh in on, if the appropriate instruction was given, I mean, that clearly factors in. Does that answer the question? I mean, I think you have to look at the whole context. You look at, I mean, I know that there's case law that says when it comes to jury instructions, you look at the instructions as a whole. You don't isolate any one. So I would think that then if you look at the instructions as a whole and see if did they fairly and accurately state the law that should apply to this case. And in the case of a missing instruction or a instruction that was not given, you just go through that process. Was it legally appropriate? Was it factually appropriate? And then if it meets both of those, it wasn't given, was it harmless? And then you look at the overall context of all the instructions and the evidence and so on and decide whether or not it was harmless. I don't think you really need to get that far because this wasn't legally or factually appropriate. It certainly wasn't factually appropriate. There were no informants that testified. Did all that rambling answer your question in a coherent way?
I believe so. Thank you.
Okay. And then finally, the last issue, well, obviously with the cumulative error issue, as I posit there are no errors, either prosecutorial or instructional to accumulate. So there can be no cumulative error. But even if there were, as I laid out in the brief, the evidence of Ms. Lyles' guilt was fairly overwhelming. And I think it is important, while my opposing counsel pointed out that Mays and Folsom were not entirely consistent. Well, any witnesses in any given case are never entirely consistent because everybody views things from a different perspective and has slightly different memory. But what is interesting is how much consistency there is between their testimony. When you recognize these two are coming from very different viewpoints, both not just physically, but also in terms of their involvement in the crime. Mays started out as a victim and then was, eventually sort of compelled to become a participant in the crimes, whereas Folsom was more of a bit of a bystander for most of it and participated just enough to keep himself from becoming a victim. Of course, as the accomplice testimony instruction says, you view their testimony with caution, but they were both fairly consistent with most of the, in the broad strokes of what happened that night. And I think when you put all that together, the evidence of Miss Lyles' guilt is pretty overwhelming. And I suppose nothing more than after she left, if she wasn't part of the crime, she perfectly had the opportunity to go to the police, call 911, let somebody know, hey, there's something going on at my house. They kidnapped 3 people and hold them at gunpoint, and I don't agree with that. But she didn't do that. All the evidence pointed out that she was a participant the whole time in the kidnapping and holding of these people in the house. And then when she left, the testimony was she was told to go somewhere and be on camera so that she'd have an alibi. So she went to Walmart, where she was in fact caught on camera. And in that time, she never made any kind of an effort to report the crime as if one who was not a participant would do. So you add all that together, and I think the evidence is pretty overwhelming that if you find any error at all, it was harmless. Then getting to this issue of sentencing, I think, Justice Biles, he hit the nail on the head. I mean, there's a handshake at best. We don't know what the terms of this agreement were. There was nothing written down. The defense made no effort to make a record or to build a record from which you could find error. And basically the state said, look, she didn't uphold her end of the bargain. I mean, that's, she says the state didn't hold up their end of the bargain. We don't know what the bargain was, but both sides are within their within their boundaries there to say the other side didn't uphold their end of the bargain, and you can't say either one is wrong or is an error. Now, I will say that I think part of the problem is, I've recently wrote the brief on the Lowry appeal, and certainly what the state found problem with was the fact that in her testimony there, she tried to minimize his culpability. That was her boyfriend. So that may, now I'm simply speculating at this point, having read both records now, as to what the prosecutor here had a problem with, but he certainly had a problem with her testimony in the other case and didn't feel like she lived up to her end of the bargain. And it was certainly within his rights to say, look, you did not live up to your end of the bargain. There's no way for us to look at this record and determine one way or the other that who's right here. It was at best a handshake, and the defense counsel, he didn't really push the issue. All he did, he's told the sentencing judge, look, we believe Ms. Lyles did uphold her end of the bargain, so please take that into consideration when you sentence her. So I don't think you can find, on this record, you certainly cannot find any kind of error or violation of any agreement on the part of the state. And if there are no further questions, that concludes the argument that I have. And I would simply ask the court to affirm the district court and uphold Ms. Lyles' convictions and sentences.
Thank you, counsel. Ms. Carver-Allman, you reserve 3 minutes.
Sure, just a couple points. I think I reserved 2 minutes, but I'll take 3 if you want to give it to me. So just to answer Justice Biles' question, the Dixon case, it's not entirely clear what Mr. Hall in that case, what was going on in that case. The opinion says that his agreement to testify was part of a probation order. So that is, perhaps not squarely on point with where we are here, but it's also a little more on point than a typical plea agreement sort of situation. As far as what happened in Mr. Lowry's trial, that record isn't before that court, and I would argue strongly that it's inappropriate for this court to consider that record. What the prosecutor said here, what the record said here, was that she testified the same way as she did at this trial, and that's the record that the court has in front of them. So to the extent that something may or may not have happened at Mr. Lowry's trial, nobody brought that up here in this record, and so I would argue that that's just outside the bounds of what the court can consider today. If there are no other questions, I think that concludes my presentation, and we would just ask you to reverse Ms. Lyles' convictions, reverse her case for a new sentencing hearing. Thank you.
I'm a little confused by your comment from your earlier argument about what was requested at the instructions conference, because I pulled up the transcript while we were talking. No offense, Mr. Elslager, but I was doing something else while you were talking. But they clearly asked for an informant instruction.
So they asked,
and that's what was rejected. And then as I read this transcript, then defense counsel says, well, could we go back on the accomplice instruction and maybe just add that they were getting some benefits? But what was requested was an informant instruction, and the court ruled that was inappropriate. And then as to this other little bit of adding on to the pick instruction, the court said that's adequately implied by what's stated here, and you can argue it all you want. And that's what they did. So I don't see how the question is anything different than a requested instruction that wasn't given, and using that analytical model rather than trying to morph it into something else. Does that make sense?
Are we talking about, just so I make sure I answer your question, are we talking about the instructional issue, so issue 2 in the brief?
Yes.
Okay, so it is our position, yes, initially the defense attorney did request the informant instruction, and then there was some argument back and forth that the informant instruction wasn't appropriate because these weren't informants. They weren't agents of the state when this was happening. And so then the defense attorney said, okay, well, we should say that they are witnesses testifying in exchange for benefits. And that is not covered by the instruction talking about being accomplices. That's a different sort of bias. And the court recognized that. And I think it was in Allison that the court recognized that those are 2 different kinds of bias here. your bias to be sort of minimizing your participation in the crime as an accomplice, and your bias to testify a certain way because the state is offering you, in this case, some incredibly significant benefits. And those are two different kinds of biases. And as we argue in our brief too, there is something harmful as well when you emphasize, jury, consider this kind of testimony very, very carefully, but then not this other thing that they also should be considering very, very carefully, again, per our case law, per the Allison case. And I think that naturally tends to make the jury think, okay, we don't need to look at that as carefully. We don't need to look at that as carefully as we look at this other bias. And in this case, again, Mr. Mays received significantly lower charges. Mr. Folsom was barely charged at all. That was a huge benefit here.
But the prosecutor told the jury to take those benefits into consideration when considering whether their testimony should be believed. I'm trying to figure out why there's a problem here.
Sure. Well, and I would divert back to our instructions that we give, that arguments of counsel aren't the law, aren't the instructions. And a court instructing is different than a prosecutor saying in closing argument for that reason. And I think this court, uses that instruction a lot to say that other problems in the instructions weren't important. And here, I think it kind of cuts the other way.
Okay.
Any other questions? Okay. Thank you, counsel. The court will take this appeal under advisement. Mr. Hazlitt, is your camera turned off?
I'm trying.
There we are. Okay.
I can just never do it right.
May it please the court. The second case for the 1:30 p.m. docket, appeal number 116541, in the matter of Scott M. McFall, original action and attorney discipline. The appellant has reserved 5 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Would you please state your appearances?
May it please the court, Stan Hazlitt appearing for the Disciplinary Administrator's Office.
May it please the court, Scott McFall appears as respondent pro se.
Mr. Hazlitt?
Your Honor, this is kind of an unusual case. On March 30th of 2021, this court issued an order to show cause to Mr. McFall. That order required the respondent to explain to this court today why he did not comply with an order of this court, which was issued on January 19th of 2017. The order was for the respondent to work with KLAP to submit a medical or psychological evaluation within 60 days of that January 19th order. A little procedural background. The panel hearing was held in this case on July 7th of 2016. There were really 4 instances of misconduct. There was a failure by the respondent to file a criminal appeal. There were 2 instances where the respondent failed to cooperate during investigations instituted by this office. And there were instances of the respondent practicing law when he was administratively suspended, whether it was for attorney registration fees, failing to pay those, or CLE requirements. The hearing panel and our office recommended a 90-day suspension with a reinstatement hearing. There was compelling mitigation in this case. There was an indication from the respondent that he suffered from depression and adult attention deficit disorder. He was surprised by the fact that his wife had filed for divorce. His oldest son was suffering from a neurological condition, and the ultimate tragedy, his other son, his youngest son, passed away. The matter was set for hearing before this court in January of 2017, and just prior to the respondent's appearance, he requested that he be, through counsel, be placed on disabled status because of the depression and anxiety due to the circumstances I just described. The respondent also requested that this court order an evaluation our office did not oppose the request made by the respondent. We did request that the respondent work with KLAB in obtaining an evaluation. On January 19th of 2017, the court placed the respondent on disabled and active status, and they ordered the respondent to work with KLAB to obtain that medical or psychological evaluation testing within 60 days. The evaluation was then to be filed and served under seal and served on the parties. On February 21, 2021, because the evaluation was never filed, this court ordered our office and the respondent to file a report advising the status of the case by March 15th of 2021. We filed a status report that day. I had made contact with the respondent. My investigator was able to find him. He acknowledged that he had not obtained the evaluation and that he would certainly appear before the court today to explain why he had not done so. We requested then that an order to show cause be issued so that the respondent would be here today to explain why he did not comply with the order. And that order to show cause was issued on March 30th of 2021. I've had actually a number of conversations with Mr. McFall. He's probably tired of hearing from me, a number of conversations actually today. And we would like to make a joint recommendation to the court to resolve this rather unique situation. Before making the recommendation, again, I want to emphasize that the respondent understands that in a few minutes he's going to have to explain to you why it was he didn't comply with your order back in January of 2017. I want to preface the recommendation by stating that the respondent in his conversations with me has indicated that he feels he is capable of defending himself at the present time. He has agreed to be removed from disabled status, and what I thought and what I suggested to the respondent was that it would be appropriate to remove him from that status and place him to have him be temporarily suspended. As long as he's on disabled and active status, we really, pursuant to the rules, we can't start up the disciplinary process again. So we would request that change be made. We would also request that the matter be remanded to a hearing panel for the respondent's testimony about what's been going on for the last 4 years in his life, addressing his health issues. And I also think the panel should be able to consider whatever this court decides is the appropriate remedy for the order with respect to the order to show cause. The panel then could make a new recommendation to the court. I checked this morning, and Gay Tibbetts and John Duma were the two board members who were on this panel, and they are both still on the board, so they would be available to be on the board if you choose to follow this recommendation. And then ultimately, we would appear before the court again to argue the case, present the case, and then the court could dispose of it as it sees fit. I'd be happy to answer any questions.
Mr. Hazlitt, I assume you're proceeding under Rule 234.
Correct.
And there's under Section D4, Roman numeral 4, states that if an attorney refuses to submit to an examination when required under Section 2D2 or fails to appear for a scheduled appointment for an examination, the Supreme Court will issue a order temporarily suspended. Is that the mechanism that we would move to the temporary suspension? Or is this some sort of agreement that you have that he'll move to temporary suspension?
I'm sorry. It's an agreement that we have, but you certainly could proceed under D4. Although I didn't specifically look at, I'll admit to you, I didn't specifically look at that section, but it looks to me like that you could.
So by agreement, we could just agree that you would move for temporary suspension, and that would be another way to do this?
Well, I looked at the temporary suspension rule too, and it says that I need to make a motion our office needs to make a motion to temporarily suspend somebody. So I thought I could proceed that way. It looks like D4 4 would work as well. I don't know that there's a specific provision that just allows somebody other than those 2 provisions just to be switched from one place to the other. But I'd certainly be happy to make the motion to do so.
Thank you.
Any other questions? Mr. McFall?
Your Honor, just may it please the court. One thing to fill in on timeline is near the end of that January 2017 or 16, I talked to Judge Moriarty, and he recommended that I go in for treatment. And I actually went to Valley Hope for 30 days and was gone for the entire month of February and then got out in March. For the last 4 years, I've been sober. And during that time, I've I've reevaluated what I've been doing and have actually, the first order of business is I went and I found a job that did not involve the law. And I've been doing that since then. I did not comply with the order. I did not get this done through KLAP, and I agree with Mr. Hazlitt's recommendations on this.
And I take it you agree with Mr. Hazlitt's representation to us that you're comfortable defending yourself at this point in time, or representing yourself?
Yes, Your Honor.
All right. Any other questions? Okay. Thank you, Mr. McFall. Mr. Hazlitt, is there anything else you would add?
No, Your Honor.
This process, Mr. Hazlitt, you're going to move for temporary suspension under one rule or the other if we grant it, and then that will allow the disciplinary process to take place. I just want to make sure I understand this. And how soon would then that be taken back up?
I think the
disciplinary process goes.
I think we could get that set very quickly. I do. I think if I make a motion under one of the 2 rules that we've been talking about to remove him from disabled status to being temporarily suspended, I think we can do it very quickly. I do think though you would have to remand it back to the panel.
And let me understand the posture of that. It was set for hearing with us and then placed on disability status. Is that what happened?
Correct.
Okay. All right. Thank you.
Mm-hmm.
Any other questions? Before we close this proceeding and recording, Mr. McFall, I hope you understand that the comments I'm making here are disassociated from your hearing and don't influence it in any way. But I feel that I want to call out that this is likely Mr. Hazlitt's last appearance before this court as an attorney of record in any matter, because he has announced his retirement. And that will be effective before we held another docket. And I don't believe Mr. Hazlitt's scheduled for anything else this week unless I've missed something. And the court would be remiss, and I hope, Mr. McFall, you understand that we want to acknowledge his long career with the disciplinary's office and as our several decades as our disciplinary administrator. And in that time has had, I couldn't even imagine he would be able to count the number of attorneys he's worked with. And I think you probably know, Mr. McFall, from your dealings with him, that he does take a position of protecting the public, but at the same time trying to find an outcome that's a holistic outcome that also works for the benefit of the individuals involved as well. And so we, as a court, will take this opportunity to thank you, Mr. Hazlitt, for all of that good work and for your many appearances before this court, always in a professional manner.
Thank you, Chief Justice Luker. I appreciate that.
All right, with that, we will recess the court until 9 a.m. tomorrow morning.